Hi everyone, it's a pleasure to start another panel of this excellent conference of IBCI, the fourth annual conference on competition and innovation. It's a pleasure to be here with such important professors and friends like Professor Luciana Yeung and Professor Paulo Furquim, both from INSPER, both people that I admire a lot and are role as persons and as researchers for me. And also a pleasure to have again Professor Felix here. He's a great friend of IBCI, and we learned a lot from his speech last time. So it's very good to have you here again, Professor Felix. We're going to start with you. So, Professor Felix from University of Cincinnati, it's a pleasure to have you here. The word is yours.
Okay. Hi, Vinicius. Thanks so much. It's my pleasure to be on this panel with Luciana and Paulo. Thanks to IBCI for inviting me to this conference. I had a really good time speaking with everybody earlier this year in January. So it's really great to connect again, to meet new friends and to see old friends. I'm going to begin by sharing a series of things to walk you through the latest iteration of this project that I've been working on. So this is a project that the University of Cincinnati has started. A few years ago, they were building this machine learning platform. They received this very large series of grants. The initial award was $1 million. Then we re-upped another $1 million from the Andrew W. Mellon Foundation. And so with this money, what the Digital Scholarship Center, or DSC, has done was they built this machine learning platform, and you can feed large data sets to the platform, and the platform uses modifications of topic modeling to show you latent patterns that the eye can't see. So topic modeling is this form of natural language processing. It depicts the probability that terms are going to recur across a large corpus of text or a data set. So I'm going to begin with showing you what the case law access project looks like. Some of you who are doing this type of computational work might have come across the case law access project if you're working in the U.S. jurisdiction. So this is a collaboration with Harvard Law Library and a couple of other collaborators, but they recently digitized every published decision in almost every U.S. jurisdiction up until 2018. And so it's this massive undertaking. This is the CAP homepage, and it shows you that there are about 7 million unique cases. Just about everything that's published. Now, unpublished decisions are omitted, but this is this huge database. In my background is that I had always been really curious about the balance between antitrust and regulation. And so when I went to our librarian to try to see how federal courts balance antitrust and regulation, he had thought that their topic modeling platform might help. And so the history of the project is that it took us a couple of rounds, because at first we were negotiating licenses with Westlaw and Lexis. It was just really cumbersome. But the case law access project is really easy to work with. Their data is really clean. If you approach them and you say that you're an academic, you can have data feeds to extract the data. It's really easy. There are these rudimentary features on the case law access project where you can do some simple things as well. Here is a historical trends function where you can look at the evolution of cases over time. And I already populated this search, so I'm just going to show this to everybody. I thought this was interesting. So here, I might have to refresh this. Let's see if I can refresh this to get you a clearer look. But I did a quick search of US, which is all federal cases for antitrust and regulation. And this shows their evolution over time. Let me know if you can't see this, because I'm not seeing the entire window here, but this is just a very rudimentary, some pretty rudimentary algorithms that you can play with on the Case Law Access Project's website. Okay, so because this is a panel more on the judiciary and judicial decisions, let me go straight to the results then. What we had done when we partnered with the Digital Scholarship Center is we loaded all these cases onto the platform. We ended up with two corpora, or two bodies of federal antitrust decisions. So the first is that we had every federal case with the word antitrust in it. So that ends up being about 35,000 unique federal decisions. And the second is every federal case with the word regulation in it. So that's 306,000 cases. It's a huge corpus of cases. Now, my two research questions were, I just wanted to test out how this platform works. I just wanted to see how courts balance antitrust and regulation and how courts approach market power. So we further filter these two corpora down. We have every federal case with the term antitrust and regulation. That's about 7,300 cases. And then the second corpus was we had every federal case with the term antitrust and market power. So that's 2,500 cases. So let's look at what the platform shows of the first corpus. Now, here, this is the regulation in antitrust corpus. Here, we further filtered it down so that we only have 2,720 unique cases. It turns out that you have to do a little bit further filtering because sometimes a case might have the term antitrust in regulation, maybe only once. And so we thought that to get greater likelihood that we would get relevant cases, we filter this down to where the recurrence of terms is greater than like 25 instances per case. So this is the first version of topic modeling that DSC has really pioneered. So this is called, this is a multi-level view. So what they do is they aggregate many iterations of topic models so that over time, when you compound topics, you begin to see topics getting together into clusters. Now, usually when you do topic modeling, you have this breakdown, which is, you run this through the machine learning algorithm naturally spits out, these are all the recurring terms. And for all the recurring terms, they will group in a topic. But what this variation on topic modeling, it's called aggregated topic modeling, does, I may have to increase the size of this slightly so that you can all see, but what this does is it gets you all the different topics and it concatenates them into clusters. So now you have clusters of topics. So when you have a question like, well, every federal case with the term antitrust and regulation, how do they splinter? And we see here that they splinter into these pretty clear clusters. So we begin with 15 major clusters. You can run these algorithms so that you can specify exactly how many clusters you want. I'm happy to talk about the data science behind this, but through a series of testing to validate the results, we went with coherence testing just to see how closely the results cohered, with the semantic meaning of the terms in the clusters. We decided to go with 15 topics. So if you have this corpus of 2,720 cases that have the terms antitrust and regulation, this is what the vocabularies begin to look like that begin to cluster together. So you have here in cluster 12, you have what looks like in an immunity cluster. So this would be Norr-Pennington cases where antitrust will defer to state action. Here, sometimes you might get some cases that are in the order of antitrust deference to regulation. So like in the US, these are classic cases like Trinco, Credit Suisse. Older cases would be like Silver and Gordon, where, if you have regulation that speaks, the thinking is that competition law and policy should defer. So here we're able to go into the cluster and then see here there are, different topics within the cluster. If we click on those, DSC has built a really nice interface where you can actually pull up the relevant cases, and that's on the left-hand side. For the sake of time, I'm just going to go through what these clusters are thematically to give you a bird's eye view of these clusters. So what's really interesting is that in this second cluster, this is a class actions cluster. Later, I'm going to show you a different visualization, which shows that over time, you can see the proportion of topics within this cluster. Some of them are more prominent over time, some of them are less prominent. What seems to be pretty consistent in these federal antitrust decisions that over time we're going to get a lot more litigation clusters. So a lot more private litigation over time. And that's true for both the antitrust regulation and the market power corpus. This is just a whole bunch of cases where you've got some sort of conspiracy claims, and these are the top terms. So next we have like a health cluster. So these would be health cases, or more precisely, given the corpus, these are probably going to be cases where there's some sort of private litigation over competition concerns when you got health regulation as an overlay. Here's some other stuff here, commerce and interstate. For some reason, you see cluster 14, there's always a milk cluster. And I think part of this is because some of these are dairy cases. So in the US, you have these dairy organizations, organizations of dairy farmers. And in the 1970s and 80s, there were a whole bunch of milk powder cases that the Department of Justice had promulgated, where it's like manufacturers of milk powder had colluded together. Here's another preemption cluster. I think that would be related to the first. You're going to see this energy cluster. That's cluster 3. Like FERC is an energy regulator. The rates that energy companies may charge, and sometimes you may have private litigation there. There's always going to be a telecom cluster. So this is, I think, is kind of interesting, because what happens is, we know that as a matter of doctrine. What happens over time is we begin to move away from rate regulation. This is this very old paradigm that you see in the US. And I think, in some countries in Latin America, you do see that as well, where you have stronger government intervention, where the government is going to set the rates. And if you depart from the rates, you have to have some sort of a hearing to justify the departure. So in the US, it's called the filed rate doctrine. Now, telecom is particularly interesting. You can't quite see the breakdown over time. And later, I'm going to show you a histogram. But telecom is really interesting because over time, we begin to get more and more regulation that is really deregulating the telecom and other sectors. So instead of this filed rate doctrine, what we see over time is that, the agencies begin to have this baseline where they will say, this is what competition looks like. And, major players will have to compete against one another. And then everything else kind of falls by the wayside. They don't tend to worry about as much about the filed rate, about, maybe access for all. Okay, so just to breeze through this, we have a banking and securities cluster, a labor cluster. Here's another telecom. And then another rubric of some sort of rates. A patent, there's always an intellectual property cluster. And then here's another like litigation type cluster where a lot of this deals with evidence and expert testimony. Okay, so now let me show you this other visualization that we've populated. So this is a more traditional iteration of topic modeling. This is not one where we've aggregated the results into clusters, but this is just your standard. You've got the top terms within the topics. Now, here you can see the proportion of the cluster within the corpus. You see over time where it shows you these kind of histograms of these cases over time where they ebb and flow. I'm going to show you another view where you can see more clearly over time, some cases begin to diminish importance, other cases or other clusters really begin to increase in importance. So here, and I can highlight it and show you immediately that there's this class actions cluster that sure enough, when you go to a histogram, you're seeing develop over time. And here, when I click there, we've designed this interface so that you can see the top decisions and also the top terms. But here, for our purposes, you've got this histogram. Over time, you see this real rise of class actions cases. I'm going to go back maybe one more time just to highlight a couple of other things here and to look at what are some of the things that might have declined over time. So you see topic 11 where it deals with commission cases, and these are regulatory cases. So you see here there's FERC, carriers, so that's going to deal with energy. What happens is that over time, we know in the US there's fewer and less activity that's happening in regulated industries, and that's consistent with this general notion of deregulation over time. I'm going to skip ahead. There's really a lot that I would be happy to talk about, but I don't think I have a whole bunch of time. So maybe I'm going to switch gears really quickly and talk to you a little bit about the methodology. So in data science, you can see this stuff all the time, but you're going to have several questions. So when you have work like computational antitrust, you really have to bring in, computer scientists, data scientists, and we're working with a lot of digital humanists who've dealt with topic modeling for a long time. So it's really important to validate the data sets. You can do that in a couple of ways. One of the ways is to have randomized parts of the data sets. So to run these same searches again and again over random slivers to see if the results you're getting are consistent over time. The other thing that you can do is what we did is have coherence tests. And so my colleagues at DSC, you'd have randomized testing to see if the vocabulary that's in each topic really coheres with their semantic meaning. So what we found over time in running the coherence test is that we used the entire corpus as a baseline. The coherence tests, they're okay. You know, they're in the realm of 0.3 to 0.4. Ideally, you want to see 0.5, a little bit higher. But what's really interesting is that they're fairly consistent, even if we take randomized slivers. So what that tells us is that in the US, when you have these decisions, the legal vocabulary is really similar. You've got this standardized vocabulary. I think that's kind of interesting just from a linguistic standpoint and a stylistic standpoint. The coherence scores are a little bit higher when we do the more precise coherence testing over the two corpora, over the market power corpus and the antitrust and regulation corpus. Some of the other things I want to talk about, the critiques that have emanated from computer science and digital humanities about topic modeling, and also some of this other stuff, some of the big data, machine learning, and the use of AI, it's that this is really decontextualized, which is, you know, this is all really fancy, and this might look really neat, but like, what's the whole point of it all? You know, this decontextualization. And so the decontextualization is this challenge that's often levied by humanists. And it's particularly important for us because in law, we're used to very close readings of text. So the context is really, really important. And one of the responses of DSC to this challenge of decontextualization has been this approach where we've aggregated the topics so that you can see them over clusters. And this is that aggregated modeling. And now I'm going to a different corpus just to illustrate. This is the market power corpus. Earlier, we were at the antitrust and regulation corpus. In the market power corpus, we've got 2,591 cases. So one thing you can do is, this is a neural network vision. The neural network vision is something that you might be used to if you've seen things like, you know, like Google Word to Vec, which is to say, we're going to put this as a spatial arrangement in different vectors in space. And so you can begin to see what the connections are. And this is me making the filters more sensitive to show you where the connectors are. And that is, you can see where these topics and topics clusters look like as a sort of, you know, neural network. So here, this is cluster 6. It's some sort of tying cluster. So that's one thing that we try to do to get you greater contextualization, which is this spatial arrangement. The other thing is that to get you greater contextualization is just the sheer act of putting the topics into topic clusters is going to get you both macro perspective in that you can see how the clusters come together, but we also have this document retrieval panel on the right so that you can pull up the cases, so it gives you micro perspective as well. What we're doing is, you know, if you go to a topic cluster like, you know, commission, FCC rates, like these being the top terms, let's see what some of the top cases say. And then you can begin to read through those to make sure that there's some sort of coherence in both the language and expression of the cases, and also the coherence with whether these top terms are found there, whether these cases belong in these topic clusters. So you can kind of see that in this tree network, where it shows you very clearly the clusters. If you highlight on the clusters, it breaks it down into different topics. Circle view was something that TSC had built, which is if you highlight a term, it shows you its recurrence across different topics and topic clusters. So this is our response to some of the challenges about decontextualization, or some of the criticisms that have emanated from digital humanities. Maybe what I can do in my remaining time is work through some of the more, just to show you how maybe some of the doctrine has evolved. And in thinking through some of the classic big data cases, or some of the big data studies that have been done prior to having this computational capability, you know, there's this really well-known study from the 1980s by Stephen Salop. It's the Salop and White study. It's this Georgetown private antitrust litigation study. So there, they had a whole bunch of cases and looked at the settlement, and it's a little bit different. We're comparing apples and oranges because we're actually looking at decisions that have made their way through the judiciary, and you can actually get a decision, and they're just looking at federal or they're just looking at private antitrust litigation. So it's really kind of interesting to compare our results with their results. The thing that I wanted to show you perhaps the last thing that I can show you is just to go to this market power perspective, which to show you kind of the histogram of cases and how that's evolved over time. So earlier we saw this with the antitrust and regulation. Now, what's really notable from that Salep and White study from 1984, that Georgetown private antitrust litigation, is they found that a lot of the plaintiffs and defendants hailed from the manufacturing setting, so the manufacturing sectors. That makes a lot of sense. You know, if you think back to US antitrust jurisprudence throughout the 70s and particularly the 1980s, a lot of these were, you know, a lot of manufacturing cases. You've got a whole bunch of Japanese electronics that's coming into the US. But what's interesting is that now we have a longer arc with which to examine these types of decisions. Now, because the Case Law Access Project takes us all the way to 2018, we see here, you know, the decline of this time topic. But if you look a little bit more closely at some of the terms here, you've got like distributor cases and manufacturing in here. That begins to decline over time. So that does decline over time. What's replacing it? Well, you're getting more topics around things like just general private litigation, so like class actions, evidentiary considerations. Here you've got more conspiracy allegations. That is something that I think is really, really interesting in terms of just illustrating the trends over time. Let's see, I think maybe I have just a few more seconds. I know we wanted to keep these presentations to just 20 minutes. I think the last thing that I'll say is just I'm really excited about where this project is heading. So at this point, you know, we're still pairing topic modeling with traditional research methods. And so I think it's interesting because when we run similar searches on Lexis and Westlaw, we don't always get the same thing. So if I do antitrust and regulation, the top cases that come up aren't going to be the top cases that come up here. That makes sense. You know, our definition of relevance is much more mathematical, which is the propensity of these terms kind of to coexist, to be populated or to recur around one another. So the definition of relevance is a little bit different. But I think that being really transparent with our methodology, hopefully it's going to push Lexis and Westlaw to be more transparent with what their algorithms are. You know, and then we're working with students at the University of Cincinnati to teach them things like Python and hopefully data literacy and data justice. So I think that's going to be really the frontier of legal education. I find that's something that's particularly interesting to me. And with that, I'll stop sharing.
Thank you, Felix. Your presentation, your project is impressive. It's the second time we have here, and second time we are amazed with this presentation, with your project in University of Cincinnati. Thank you very much. So now let's have the word for Paulo, Professor Paulo Furquim. The word is yours. Thank you very much for taking part.
My pleasure, Vinicius. Thanks a lot. And I also thank the IBCI organizers, Eduardo Gaban, yourself, Vinicius, for having me here, and also for the invitation, Luciana. And you are doing, I think, probably, I don't know if everyone knows that you are proceeding with a research exactly in judicial review. So I'm looking forward to your results. And it was great to attend here the presentation by Felix's fantastic tool for research in legal empirical studies. And I was impressed not only by the methodology, that is great, but also with the interface. We've been working with data scientists in some projects here, but it's like we have still a gap for communicating the results of data science with the people that work mainly strictly in law. No? But this is really a fantastic frontier for research, for legal studies, and also for the profession. I think the future of the profession will be, is still already, I mean, already it is, in this area of text analysis. Well, my presentation, I will try to be as strict with time as Felix. This will be hard, but I'll do my best. So I'm controlling here my 20 minutes. And I will share with you a presentation. My presentation will be more conventional. I mean, not only because I will share my views on the subject, not only methodology, it's more about judicial review as a subject. I do have some empirical evidence here, but it's not about the methodology. And the methodology in this case is more conventional. And by the way, the data that I'm bringing here is not a brand new data, is something that research that I have for 4 or 5 years ago, and I just adding some new evidence on that. So let's move on. So now I think, are you seeing my slides changing or not? Yes? Okay. So let's begin with this idea of judicial review in administrative decisions, regulatory decisions. So the first question, I will try to be fast here, is why we do have regulatory agencies. So why not just judicial enforcement by the judiciary? And the idea is to have when you have in these sectors that are regulated, the timing of the decision is very important. Also, the subject is very specialized, so we see the need of concentrated knowledge in the agency, and also the timing of responses has to be fast. Why I'm stressing this? Because judicial review will affect a lot the time of response of this the regulation as a whole. And also, it's very important to have the credible commitment between the companies that are regulated and the state. So that's the reason. And then we have to ask why we do have a judicial review of the administrative decisions. And we have, I think that the easy answer, we need to have checks and balances. We cannot have full power for just 5 to 6 or 7 people to decide the future of companies in a sector that is regulated. Also, we have an idea of error correction. So when you have more instances of decisions, the final decision, there is this expectation at least will be less subject to decision errors. So this is, of course, one important reason. And finally, we have I think this is less mentioned, but when an agency is about to be reviewed by the judiciary, this changes the behavior of the agents. In particular, this is important for due process. So, are you really seeing the slides changing? Yes, okay.
Yes, but
sorry,
it's not
because I have
Paulo.
two monitors here and one is not changing, so that's the reason I asked you. But what I just said is the ideal of judicial review. So the question is, what is the reality about judicial review? And of course, I will talk about Brazil, but this I think is it's something that can be generalized for Latin America and more broadly to civil law countries, that we have this administrative system and a judiciary that has some particular features. And so the principle here, when we decide, when we see the discussion, what should the judiciary review, and I'm quoting here Professor Carlos Arissunfeld, that I think all the Brazilians know about him. Normally he says about the control of abuse. The judiciary should concentrate on the control of abuses of the agencies and not on decisions on the merit. But actually, this is very difficult to be implemented. Who is going to decide what is an abuse of the authority and what is the decision of the merit? Is the judiciary itself. So it's not really easy to be implemented. The facts that we have in Brazil is that we have lengthy judicial proceedings, very, very lengthy, and also is a source of uncertainty because the decision changes frequently. and not necessarily better decisions. So that's what we really have. So in this illustration that we have is of this process, and why I'm going to also link the problem of judicial review with the problem of settlements. We have an administrative authority, and the administrative authority may ended up with two different types of decisions: unilateral decision that may be restrictive, or a settlement, so a negotiated procedure. So there is something happening inside the agency, or the relationship between the agency and companies, that may ended up in different outcomes, unilateral decision or settlement. If we have an unilateral decision, then we have the private party may appeal to courts or to comply with the decision. So there is this game theoretical tree here. And we can see now that settlements may play a crucial role to understand what really will be appealed to the courts. And this will be one of my main points in the minutes that I have ahead. So there is a question also why parts will appeal against a regulatory agency decision. So why they go from the unilateral decision as to courts. And there is, I think, several reasons, and maybe more reasons here than I have time to go through then, but I will highlight some of them. It's first, they think there is a, let's say, a proper understanding of the application of law, and the agency was not really able to decide properly. So they want a review just to have the proper understanding of the law in their particular case. But there is also one, I think, legitimate reason for appealing, which is moments that we have a new law, we may have the questions how to apply properly the law. So there is a discussion about what's the proper really understanding of the law in concrete cases. And then we need the judiciary to settle this type of understanding. And also, we cannot forget that they may just want to postpone the regulatory decision. And if the timing of the judicial proceedings are too lengthy, this may be a very important reason for appealing to courts. Let's move ahead. Sorry. Well, there is a related literature, but I think I can skip this and go to what's the reference for this talk. So the reference for this talk that I have here as the empirical results, it's a book that was published with Professor Tércio Sampaio Ferraz. I think all the Brazilians know him, and Juliano Maranhão. And if you really are fantastic in terms of citing, you can see the name of Luciana Yeung here as one of the researchers, and she was writing about how the judiciary in the Brazil works. And so what I brought here is some data from this research. This book is available for everyone and for download for free. If you want to have this more in detail, we can go ahead. But let's see some results. What we have, one of the results that is most impressive is the average length of judicial proceedings. Sorry, it is in Portuguese, this graph, but what is really striking, when we have a case, an administrative decision that is not confirmed, that is overruled in the judiciary, it's about 70 months, the duration of the case in the judiciary, in average. Of course, we have cases that is much longer than that. This is a lot. And I have I've talked with some guys from Russia. I do not mean that it's a better system than ours. No, but it's just to contrast the results. There, the judges, they have incentive, very strong incentives to be fast. They are penalized if they have a case load from 1 year to the other year. So cases less than 1 year. So the whole proceedings in the judiciary less than 1 year. So we have here more than about 6 times higher. So of course this is long. Second feature that is, I think, a problem in our system of judicial review. Of course, if we have judicial review, we expect something to be reviewed. But what we see is that in first instance, so the first degree, we have a much higher rate of decisions being overruled than in the final, when the case is closed. So what's happening here? There is an administrative decision that is in the beginning valid. And then we have a signal from the whole institutional design of regulations of the judiciary saying that the administrative decision is not valid anymore, first instance. And then we have the second instance saying again, no, it was valid. So this is uncertainty. So the first degree overruling much more than the final outcome of this system. So this is something that's really worrying about our system, because this is a source of uncertainty. And we come up with an index of uncertainty, and we try to measure how much the decision, the administrative decision status changed, if it was valid or not valid in every case. And you see for every agency in Brazil that the numbers are, I think, in average, they are very high. If we just saw that 20% of the cases only are overruled at the end of the judicial proceedings. So we have a case like this, this indicator is saying that the cases are changing more than 1 time per year. So this is a lot, because you have preliminary injunctions, and then we have they are not valid anymore, and then we have the first instance decision. So this is changing a lot. One case in just 2 years, we have 12 changes in the status of the decision. It was a cartel case. So uncertainty is a problem in our design of judicial review. Well, I have now, I think, just 7 minutes, so I try to go direct to the I think the main points to make, and I'll do two. I'll talk about deference, and also I'll talk about settlements. What do we see? That the lack of deference is the main source of problem. So when the decision is overruled and then disconfirmed in the upper court, this is a symptom of lack of deference in the first instance. And now I have the case of 2 agencies in Brazil, and the idea they may inform about how an agency can build deference or build a reputation for the judicial review. So let's take the case of Conitec. Conitec is similar to NICE in UK. So it's an agency responsible for authorizing new technologies in the health system. And Kaiju is the competition authority in Brazil. So let's see this result by Daniel Yeung. Daniel Yeung is a researcher from FGV. And what we have in this line is the confirmation rate, success rate by the patient who is asking for a specific drug here, this analogous insulin. And it's about 90%. And here, the judiciary didn't have a position by the agency. And then the agency decided in 2014 that that particular drug should not be provided by the health system. So there was an in-depth analysis of cost and benefits, efficacy, that this drug should not be provided by the health system. And what we observe in the judicial decision pattern, nothing. So no deference at all. So the decision of Conitec was absolutely irrelevant for the decisions of the judge. So this is an extreme of lack of deference. What we see in Kaji's case. So this is, let's focus on this blue line. This blue line is the rate of success of Kaji in the judiciary. Sorry, this is not the rate of success. This is the number of cases of Kaji that ended up in the judiciary that were appealed. But this is similar to the success rate of Kaji in the judiciary. What we see is that about 70% of the decisions of Kaji were appealed in the beginning, and then after like 25, they dropped dramatically, and they are like now, even today, about 15, 20% of the decisions are appealed. So what happened? What happened was that the judiciary started to give decisions in favor of Kaji, and litigants, they know that they will lose if they appeal against Kaji. So the consequence, they don't appeal anymore at the same rate. So they started to settle the case before. And this leads us to a previous conclusions that it's important to build deference. This was not by chance. This was not a change in the judiciary, not a change in the judiciary. This was a change in how Kaji interacted with the judiciary. So it was something that was deliberate strategy by the agency to gain the confidence of the judiciary, and then in building deference. So a strategy to build deference. Okay, let's move to my final point. It's about settlement. One of the things that Kaji did was to foster or to incentivize settlements, negotiated decisions in the administrative sphere. And this is, of course, if you settle the case, there are a lower group of cases that are able to, or that can be appealed, of course, because you have settled the case before the judiciary. So a way to avoid the judiciary settling the case. And we must ask, what are the consequences of doing this? Now you skip this. So we have some regressions, but the main findings from this analysis is that settlements were indeed used to avoid courts. So the agency doesn't want to be reviewed by the judiciary and have a strategic movement to settle case in the administrative sphere. Okay, this is expected by the agency, but is it good? What's the consequence of that? One of the consequences is a process of selection of litigators. Who is going to accept the settlement? Normally, if we go back to the reasons to litigate, we see that one of the reasons was to postpone the regulatory decision. So guys that they knew that they would lose the case in the judiciary after 6, 7, 8 years. They will have to comply the regulatory decision of 7 years, but they may buy time. And time is valuable in this area. So the companies that are not settling the cases in the administrative sphere are what we may call bad litigators, because they are entering the judiciary just to postpone a decision. And this also is consistent with what we see in the data, that is increasing deference of Kaju's decision, because the litigators that are entering are the ones that are most likely to lose the case. The ones that are most likely to win the case may settle the case before if they have some value for timing. They don't see a value for postponing the decision. And for that reason, I think we do have a problem here. Well, the judiciary is not really playing the primary role of adjudication, is being used for postponing the cases. So I think I'm done with my time. And when you see judicial review in Brazil, although we have a fantastic system, ideally, in reality, we see several problems in the implementation of judicial review. And thanks a lot for your time.
Thank you, Professor Paulo, for a brilliant presentation. I have the book here in my. It's a very good book. I read the book and use it in classes about that subject. And Luciana Yeung is on the research. That time is going to be again. So Luciana Yeung is always researching this topic. And now I'm going to switch the word to Luciana and me, because we're going to do a joint presentation. Professor Luciana Yeung from INSPER. So it's just an idea, initial research, but then Luciana, do you want to share the screen, or do you want to? Yes, so we're going to do like a presentation together. So we're going to have more time for discussions and things like that. And so the idea is to discuss levels of deference in Brazil in our work, because we think that one of the things the discussion could be improved is the why and the reason why there are some different levels of deference. So different courts, like for instance, Professor Paulo showed his results, and like ANEL, that's the electric energy agency, has not so much deference, and some other agencies have more. You can say that this is because of the way that agency interacts with the judiciary, but there is an objective way to see if the agency deserves more deference, or it must be punished like with less deference by the judiciary. This is the question we are researching. And the thing about the literature, I think, is the same as Paulo, almost the same as Professor Paulo presented. The idea from, for instance, from that work from Adolfo Jordan and Professor Sus Ackerman, that it's important for the review is important for rights and things, and to see to correct errors and things like that. If wanna see, but have a problem, because if you have, as Professor Paulo Furquim said before, if you have total deference, then there is no error correction, and if there is total deference, there is no rights review, because one of the things that judicial review is important is to watch for rights and due process and things like that. But on the other way, as Professor Paulo Furquim also showed, if there is no deference, then there is no point in having the agency and make the agency doing decision, because the decision of the agency is irrelevant. So we must have like a middle position that uses some level of deference when it's needed. And the question is, when it's needed, then there is a way to see when it's needed. So we think that it could thought about that. The level of deference in a good match with the capability of agencies, because we think that there is some difference in. We see in the previous empirical works that there is some difference between the levels of deference, but I don't know if they are correlated with the capability of agencies. There is a reason for that. The judiciary doesn't have more deference to one agency than another. For instance, this is because that agency has less technical inputs or has less independence, or the staff is not so good, or there is a historical of problems in the way that agents builds the process, the inside process of decision. And this is the thing that is missing in our point of view from the research, to see why this happens. And if, for instance, there is a good agency that has independence, that has produces good technical inputs, and doesn't have so much deference than others, then maybe the reason for the deference is not well known from the literature, because there is no reason to do these different perspectives. So the literature is almost the same. And online economics, there is these questions about generalist judges and specialized agencies. So you can see that on Posner, classical work in 1974, more recent works of Steven Chevelle and Posner again, saying that it's important to see that the agency has competence to do these decisions because it's a technical decision. And Professor Joshua Wright in competition law has an interesting article saying, debating this point, saying that, for instance, at FTC, there is just the inputs from the technical experts are just inputs, and not the only ingredient in the regulatory decision process. He says, oh, okay, you say that the agency is more competent, but who decides is not the staff of the agency, is the commissioners. And sometimes it depends on the agency and on the way this decision is designed. The decision is political, it's not technical. He also says that he compares the decisions by judges that were trained in economics of antitrust, comparing to FTC decisions, and say, oh, judges that are trained in economics do better than agencies, when in reviewing and losing cases, like decisions are appealed. So he says, oh, this is not a whole explanation. There is this article, I think it was also on Professor Paulo Furquim's slide, from Spiller 92, and also from Tiller and Spiller 99. They work with these layers of judicial review that Professor Paulo showed, and he says, oh, what's the level of reducing regulatory discretion of judicial review depends on some points. One of these is how the first court has respect the higher courts has respect the lower courts. For instance, if the first instance, it's usual in that country that first instance is just one decision that can be reviewed with no problem. So it's a problem for the society because of the length of the decision, but this is the agencies knows that the judicial decision is just the first judicial decision. You're going to have more decisions. So how do you build the system of judicial review is important. And also the idea that if the final court that does the final decision, the court knows that the decision of the agency is very well connected to the way of the legislative thinking, probably there is a chance of changing the law and put that not on a regulatory decision but on a law. The same thing, because then this is gonna do some restrictions on the capability of judicial review to change the administrative discretion from the agency. But the idea that institutional quality or capabilities of the agency is important on the level of judicial review. There is no discussion of that in those papers. Of course, the first important study of this is Professor Paulo Furquim, explained, and he already spoken about this work. But there are some other works and one more recent work in 2020 that showed the same agency, like electric energy agency, that has less deference, but he find like not so much deference that in some previous studies. So this is I don't think that is a change, because his study from the last one of this slide was made just with the second level. It's the TRF in Brazil. So he didn't study the superior tribunal decisions. He studied just the TRF decisions, so the second layer. So he found less deference, but maybe it's because he didn't investigate the final layer of the decision. But this could please the next slide, or
that's mine.
Yes. So thank you very much. So now it's your time. Thank you very much.
Okay, so I don't know if Vinicius emphasized, but this is still a work in progress, and actually we just started making the design of how we are going to do that, right? We hope to do this empirical investigation, but everything that I'm going to show you is actually what we planned. We didn't started collecting the data, so we just thought that probably the conference would be a great place for us to grab, some ideas, suggestions, and criticisms, and we can start better than we planned at the beginning. So as Vinicius just mentioned, actually our main hypothesis or main question is whether there are different levels of deference according to the differences of institutional quality or capability and maturity of different agencies. Therefore, what we plan to do is to go to the open databases of judicial decisions and from the federal courts and also the two superior courts that we have here in Brazil, the Supreme Federal Court and the Superior Court of Justice, and try to grab data on decisions related to different federal agencies, identify whether there was this sort of deference or not, review or not, and we will also relate that to the institutional capacity and quality of these different agencies, and also according to their different maturity. We will have to provide some definition about what we understand as institutional capacity or institutional quality. Probably that will be related to the maturity when these agencies were created, because actually many of them were very recently created. The wave of the creation of agencies in Brazil is very, very recent, coming from the 90s. But also we were thinking about getting another set of very objective measurements by TCU. TCU is the department within the federal government which judges and evaluates all budgets, right? Vinicius and lawyers, please help me with the definition of TCU.
It's an audit office for the spending of public expenditure, and I think TCU analyzes not just how the legality of the spending, but also the efficacy and the efficiency of the spending. So he analyzes all the agencies, of all the federal agencies, and he has some ways of doing. We can compare these audit reports.
Right, so the idea is to use these audit reports as a basis to sort of make some kind of ranking of these qualities and these more objective measurements about what we will call as institutional capacity, right? And just to give you an idea, since again, this is a very, very, very preliminary work, what we were trying to do is to have probably 3 broad categories of agencies according to this institutional quality. We'll have Kaiju, the antitrust, the competition agency in Brazil that Paulo not only presented, but also worked as one of the advisors, right? Anatel, which is the telecommunication agency, Energy, and ANEEL, which is the energy. So these are, especially Anatel and ANEEL, they are part of the first wave of the creations of these federal agencies in Brazil, and Kaiju has its own history. So these are more mature, and we would say that they are regarded as even within the government, but outside for companies and enterprises as some agencies with more reputation and institutional capacity, broadly speaking. We would probably have some with medium capacity. We still are deciding on that, but probably ANTT, which is the agency which regulates the transportation system here in Brazil, and probably some that would be considered ones with low institutional capacity. ANP, the one regulating gas, ANPD, regulating data, and also ANPM, which is a very, very recent and new. It was within, it was a department within the ministry, right, Vinicius? And now it was created a new agency for the regulation of mineral production in Brazil, which is a very important economic activity here in Brazil. What we were trying to do at the beginning, we were thinking about grabbing all this data with machine learning, with text mining, but then I think that because of the magnitude of our studies, since we are not doing an overall study of all the agencies in Brazil, we are cherry picking some agencies, specific agencies as I just showed you. Probably we will not have that many cases. I'm not sure, probably we'll have some surprises, Vinicius, but if that is true, if we are very far from the numbers that Felix got, for instances, like around close to 3,000 or 20-something hundreds, probably we'll change our minds and then we'll get some text mining. For now, we think that probably a manual codification, a manual analysis probably will make the job. Let's see how it goes, right? So basically what we are trying to look, what we will try to look our variables is first, whether there was deference to the agency standards, of course. Second, what arguments were used? I think that this will be more important for the law guys, right? What are the legal arguments or sometimes the economic arguments, but that were used to defer or to deny the regulation by the agencies? Who were the litigating parties? Which companies were these, or which associations were these? And then let's see whether this also makes some kind of difference. There was some previous work, not exactly in this theme, that the type of litigants that we have within a litigation case have some important effects on whether the case will be judged in favor or against the same party. The capacity that we will measure, and probably something else. We are still making this decision, thinking, reading and studying a little bit more, and probably you guys, whoever is in the audience, might also give us some suggestions. These basically will be our variables of analysis. So as I said, we will get these from the public databases on decisions, the judicial decisions. In Brazil, we still do not have any initiative as the one that Professor Felix is heading in Cincinnati with the Harvard guys. But luckily here in Brazil, somehow we can say that we have some, after some work, we have some easiness in getting this data. They are mainly public. We just have to get the work to grab this data, but they are mostly publicly available. So probably this will be our quantitative but also qualitative research, and we hope to combine both of this methodology, and let's see whether we will be able to confirm our hypothesis. So this is what we had for today.
Thank you very much, Luciana. This is the idea. So I'm gonna pass the word back to Felix to see if he has any reactions to the other speeches. So Felix, do you wanna say anything?
Yeah, so you say that these are public data sets. How easy are they to get? And then in terms of coding, so you're talking about manual coding, which is traditionally how you do empirical research. Now we found that machine learning is easy because you don't have to manually code it. But I guess this is more of a comment. You find that, you know, to have that human intervention of manual coding is good, to have that human oversight. You know, in data science, sometimes with machine learning, if it's truly unsupervised, it's like this black box. And so you have to do a lot of work with randomizing and with the coherence testing just to make sure that the results are okay. And so I guess my question is how easy it is to obtain the data and then to hand code, and what do you think you would lose in moving from a regime where you're hand coding a lot of data into one where you might be using an algorithm to give you where the, you know, where the topics fall or whatever?
Thanks, Felix. I'm going to answer about the easiness of getting the database. But actually, all of the courts in Brazil, especially and the higher the better, they make it available the synthesis of their decisions. So unless it is a very it has some kind of secrecy, you know, the legal secrecy, otherwise most of cases they are available even in PDF documents, files. So there is this, you know, you get into their website, and there is one page where you can write the keywords that you want and the period when the decisions were made, and then they will, you know, pop up a list of the cases that were decided, and then we'll just, if you want, just go and download the PDF files. And this means if you want to do manually, you do that. What machine learning does, what is the text mining algorithms they do, is very similar to this, but there are also some other databases, for instance, what is called the Diários Oficiais da União, which are like daily publications, official publications, in which all these decisions are also published there, and then you can go and get the data, right? So yeah, they are pretty okay, and we are, I would say that we are seeing like a new wave of empirical analysis in Brazil, of empirical studies in Brazil in law, specifically like taking advantage of the availability of this kind of data. Of course, there are always, you know, things to get better, to improve, but I think that we do have like some, I will not complain. I think that we do have some like nice database. I think that Paulo could also say something, because he coordinated some very large studies at INSPER using this text mining technique. Probably he could say something.
I think you said exactly what we have. We have this advantage here that all the decisions are, at least at some level, they are public. The judiciary the majority of courts in Brazil, they do whatever they can to avoid us to use machine learning techniques on their decisions. So they try to block our access to the website and things like that. They really they were discussing about having a law like France. They had a law, you know, so they were inspired by the French law about proposing something similar here. At the end of the day, I guess, is to avoid our analysis about the efficiency and some bias in the judiciary. Maybe it's about that. But we do have that. And what I think it's also interesting to try to incorporate in your research besides the analysis of the judicial decisions, if you can, it's not easy, is to find the decisions of the regulatory agencies that were capable of being appealed. I mean, decisions that could be appealed because they are restrictions to companies. So the regulatory agents may have decisions that are in favor of the companies or against the companies. The decisions that are against the companies are the decisions that are possibly they can go to the judiciary. If you have access to this data, in the case of Kaiju, we do have access of this data. It would be great to have this for CVM or for ANEL, for other agencies, because then you can make an analysis about the selection bias of what really goes to the court. And I think this would be interesting, even if you have just for 1, 2, or 3 agencies. And what I think suggestion is regarding the features of the agency. Besides I think the setting for the agency's capability is great. Maybe how to measure is something that you can have different proxies for how to measure capabilities. But one thing that I would also look at is if they have a policy for settlements, exactly in the way that I was talking about. Because if they do have, then this selection of what goes to the judiciary is different. And I would expect as a hypothesis that the degree of deference would be higher, but not because the judiciary is really more deferent. It's just because of the bunch of cases that go to the judiciary is a bunch of cases that is more likely to be in favor of the agency. So this is, but a great research. I'm very interested in it. I think it's a extremely relevant topic in Brazilian regulation. We normally think about regulation, and economists mostly, as what is the second best regulation, giving information asymmetry, and then you have the optimal regulation given that. But they don't think about one very important part of the design, which is the judicial review. And so regulation is everything. I mean, is the agency, but it's also the review and the final decision. The signals that you give to the companies are from this whole institutional setting.
Thank you, Paulo. Felix had the first question, right, about why we decided to go on manually. We still didn't make our minds yet, but this is more like a cost-benefit analysis, right? So if we had few cases, probably we'll just manually. And if we start by looking at the databases that we actually have a whole bunch of cases, so probably we would invest in text mining. This is just a matter of what will be faster and what are the benefits and costs for either case. This is a very personal choice of ourselves.
Thank you. That's really interesting. In China, they have these huge data dumps now where they're like these cases at the provincial level, and there are in the US some folks at Columbia and Berkeley, and also Molly Roberts, who's at UCSD, who's unleashing I think it's probably topic modeling on this huge, we're talking like millions of cases. I think it's particularly interesting to think about judicial review. So like coming from a common law jurisdiction, the variability that you have in cases is huge, even though the coherence score shows us that the style of writing is kind of consistent. There's just a lot more variability. I'd be curious to see how much variability there is in your judicial review and also China, another civil law jurisdiction.
Yeah, thank you, Felix. I don't know, Luciana, please, sorry.
I was just thanking Felix for the insights.
Thanks. No, I think there's this difference. Maybe because in civil law, if you think about judicial review, there is this rights foundation probably, and I don't know, because in common law, I have in the United States, as my impression and what I read is that the rhetoric of how you write decisions are more open and more substantive. And it's not like Brazil must have like this in Portuguese, it's syllogism. It's like you have a perfect fit between the fact and the norm, and very mechanical way of thinking. But it's not that. But I think in common law, you have a more open and a more substantial rhetoric in decisions. So if you probably by the families of law, there's going to be more coherence in civil law countries. I think that's what it is expected for civil law countries. I don't know. And I don't know. I think we're most in the time, so I'm going to pass the word to everyone to say a final remark. Let's start with Felix.
I just wanted to say it's such a privilege to be here and to talk with you all, to see what types of research you're doing. My research has become more comparative over the years, so that we're looking at different legal systems, different institutional dynamics, and also different cultures. I just think that if you truly want to understand a substantive area, I think it's really important. It's interesting to see that some of our tools and some of our perspectives, like law and economics, vis-a-vis regulation, and also these kind of big data research techniques are making their way around the world. But as an American, sometimes I'm conscious that that's not necessarily the best way. There's a lot of the attitudes of American researchers can be a little high on ourselves. So I just think that the comparative dialogue is tremendously important. So I'm very happy to be here.
Thank you, Felix. Paulo?
Well, thanks a lot for having me here. It was a great discussion. I think both methodologically with the techniques that Felix presented to us, I think there is a fantastic leeway ahead for exploring. Then in Brazil, we do have the material to do that, because we do have the text of, for instance, the case of Social Security revision that we just did research. We had 9 million texts of decisions, and this was then it was really required to do the use of algorithms to analyze them. And so it's great to, and I'm looking forward for your publications in this area. I think you're settling the ground for the research in the area. And also my congratulations to Vinicius and Luciana for the work in this case, the subject is really relevant. I mean, to understand judicial review in regulation, I think it's in Brazil in particular, I think it's very important. It's a crucial part of the Brazilian regulation.
Thank you, Paulo. Luciana?
Without again, and also thank. I'm in a little bit awkward situation here, because formerly I'm part of the IBCI, but I feel more like a guest. And so thank you very much for the organizers. Actually, my role in this conference was just this one, presenting and working with Vinicius, but it's just so great, because I know that IBCI had all this concern in bringing, international scholars, and as Felix says, it's so important to have this exchange. And of course, for myself, I'm new to these studies on regulation. I have told many times Paulo have brought me to this field, and he is responsible for that. But I'm just learning so much with you all. And of course, all this idea of having this new methodology in text mining is just so inspiring. Since when Felix first talked here at the beginning of this year, I was just so delighted and said, okay, let's try to do something, improve the things that we have been doing here in Brazil at INSPER, and with Paulo and all the folks at INSPER. So I just have this great opportunity to learn more. Thank you so much.
Thank you, Luciana. Thank you, everyone. It was a great pleasure to talk with you in this panel with people that are for me are friends, and besides, thanks everyone that was watching and everyone that participated in the panel. So tomorrow have the last day of our conference, and thank you very much for all. So see you tomorrow. Goodbye to everyone.
Bye bye.
Thank you very
Thank
much.
you.
Bye, everyone.
Take care.
Bye-bye. Thank you.
Thank you.